The Honorable, the Chief Justice, my ladies, my lords, my name is Justice Njiru Nyaga for the third appellant. And for the sake of clarity, Justice is my name, not my title. I will be addressing the questions that have been raised by the honorable judges, starting with the question of Lenaola J as to the purpose of Article 250, sub-article 1, concerning the minimum of 3. Can IEBC do some matters administratively? And the simple answer to that is no. And we wish to seek solace from the decision of the High Court in this matter, where they were explicit that the statute which has been implemented by, has been enacted pursuant to Article 88(5) does not make a distinction between administrative and policy issues. And that is a point of departure from the decision of Biwott, where the Biwott case was saying it is policy issues only. But the High Court distinguished that, and they said that is bad law, and they respectfully departed from that. So our straight answer to that is no. As per the law, they cannot even do administrative issues. To the question by Lady Justice Njoki, what is the purpose of Article 251? In essence, it just defines the composition, the minimum number of members who can compose an independent commission, because it is trite that there is safety in a multitude of councillors. And when you look at the Biwott case, the issue of quorum came up, and it was clearly defined that quorum is the minimum number that is required for a commissioner, for a commission to transact its business. So 251 states the minimum membership, but the legislation that has been enacted, that is the second schedule to the IEBC Act, clearly provides for the minimum number of commissioners to transact business, and that is 5. And we still hold that the High Court and the Court of Appeal were right in finding that that provision is still valid. Let me go quickly to the next question, and we will be pleading with the Honorable Chief Justice that for Topua's question, he can be granted his time to address it, the question on basic structure that has been raised by Honorable Lenaola J, Judge of the Supreme Court. To the question of Justice Smokin Wanjala, if membership is set at 3, and I will be requesting for just a few more minutes so that I also address Oko's, Justice Oko's question. May I proceed? Thank you. Concerning the question by Justice Smokin Wanjala, if membership is set at 3 and the quorum at 3 or is set at 3 or 2, is that bad law? We respectfully submit that that will be bad law, having in mind the important functions that the IEBC conducts. And when you look at the letter and the spirit of the Constitution, it will be wrong to have important decisions of great magnitude being transacted by only 2 commissioners. So for that, we will humbly respectfully submit that that will be bad law. Concerning the last question by Honorable Justice Oko, what is the status of the actions that were taken when the IEBC was not quorate? We respectfully submit first that what is before this court is not the matters that were taken by IEBC, such as even the composition of the court, or the by-elections. But what is before this honorable court is a question of the amendment of the Constitution. However, that being said, we take solace in the decision of this honorable court in the case of Mary Wamboi Munene versus Peter Gishuki Kingara and 2 others, a 2014 decision, where you are very clear as to the effect of a provision of a statute being declared unconstitutional. It can either be retrospective or prospective. Therefore, in this case, for matters which the court will look at and see that this, if we are to apply them retrospectively, they might have serious implications, the court can respectfully decide to have them be prospective. And therefore, we humbly submit that you do not buy into the suggestion that has been given by the Honorable, the former Attorney General, Professor Muigai, who I greatly respect, that in any such case, the default position ought to be the application is retrospective. And that is what the decision, that was your decision in the case of Mary Wambui. And allow me just to finish with what Justice Kriegler said. And this is what he mentioned. I'll read quickly in that decision, which this court rightly quoted. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado. Though it's sometimes convenient to have the court to declare it to be so, and every proceeding which is founded on it is also bad and incurably bad. You cannot put something on it and expect it to stay. It will collapse. The default position concerning this matter is that the declaration of an unconstitutional amendment to a statute should be retrospective. And for that reason, paragraph 5 and paragraph 7 of the IEBC Act, second schedule, still apply.
Thank you. Thank you. Don't rehearse. Yes, we have taken the answer. Ms. Kituku.
I will invite now Mr. Topua.